All right, we are good to go, Davis.
All right, I will start with the ethics statement and let Brian kind of go over his amended version. But members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. So with that, Brian, I think that maybe you can go through the changes you did based on our last meeting.
Yeah, so after our last meeting, I went back through the opinion. I think the big thing that, I'll just kind of say the opinion started off saying, when we have a situation where basically a lawyer is attempting to get the client's consent to regular fee increases and just simply impose them without any sort of notice other than that original fee agreement that says we may change this at some point. That seemed like that was not sufficient for the subcommittee. There needed to be some sort of notice to the client that fees were increasing, and give the client an opportunity to make some sort of decision about the representation. The original opinion said that you just can't simply impose this thing even with 30 days notice. That changed. So you'll see here. I think the easiest thing is just going to be for me to share my screen so we can go through the opinion, look at the same thing together. And of course, I sent this out to you, so you should have a copy yourselves. Basically, the first opinion that was just kind of focusing on this notion of, well, here's the fee agreement, here's the clause that just says this billing rate may change during the course of the year. We check our rates kind of regularly, and you'll be notified whenever it changes. Of course, in that scenario, that it was changed and just kind of the client was sent a bill without any sort of notice that it actually had changed. It was almost like the client learned of the change after the work had already been completed at a higher rate. And that, in this opinion, is still not permissible because there's no communication about what this new rate is going to be. There was no notice. And I did include a new line or a couple of new aspects to this first opinion. Just kind of first say that, it's that a lawyer cannot unilaterally increase the billing rate without reasonable notice to the client. And then this second part here that I added was kind of a new paragraph, and this is based upon some of the questions and some of the comments that we had during that last subcommittee meeting where we were talking about whether or not that the 20% increase that was cited in the example was clearly excessive. And I think we were all kind of dancing around the same answer that 20% increase may seem just I guess clearly excessive, unreasonable, but at the same time, it very well may be reasonable based upon the circumstances. And so we just need to state the rule, which is lawyers cannot charge clearly excessive fees. So whether or not the 20% increase that's cited in this scenario really depends upon whether it's clearly excessive, and that has its own analysis, but we're not really opining one way or another. Because we don't get into that. That's kind of an aspect that's not really a part of this particular scenario and this particular analysis, other than to note any sort of increase, whether you're talking about a 5% or a 25% increase, it just simply cannot be clearly excessive. That's the rule. So kind of tried to state that and set that out so we just kind of resolve that issue and have a reminder there to lawyers that make sure your fees are not clearly excessive. As we proceed through the opinion, the second inquiry was basically, all right, so, we're still in that scenario where a lawyer just imposed this fee, the increase to the billing rate, and the lawyer wants to withdraw after the client just refuses to pay. And that's where, the answer was no, you can't just simply withdraw because of that language in the comment. If you don't provide reasonable notice and you just simply impose a new fee and threaten to withdraw, that's kind of I think it falls under that notion in the comment to 1.5 about coercing a higher fee and threatening termination of the representation to coerce that higher fee. So you can't do that under these facts. Inquiry 3 is where the biggest change occurs. Inquiry 3 is where we're saying, all right, so we're in that same scenario where the language in the fee agreement is just we check our rates periodically. We're going to potentially increase them, and in this scenario, instead of just imposing the increase and letting the client know that they've already been billed at the higher rate, the client receives notice that of a specific proposed increase 30 days prior to the imposition of that increase. And in this one, the answer changed. Before we said, no, you can't do that. This one changed to yes, to say that 30 days notice. In this particular scenario, I don't think the rule is you have to have 30 days notice. You have to provide reasonable notice to the client. And I understand that that could be, kind of played around with, whether somebody thinks it's reasonable to give 7 days notice, 30 days notice, or whatever. Is probably going to be dependent upon the circumstances. But we basically say here that as long as the fee increase is not clearly excessive, yeah, that's okay to do. You've provided notice to the client, and looked at the language there in the comment to really kind of finesse this thing out. Saying that the attorney is essentially seeking to renegotiate the contract, and that's an okay thing for a lawyer to do. They provided that reasonable notice, gave the client sufficient time to make an informed decision about the representation. And so if, added further that if the client doesn't respond to this proposed increase, provided in light of this sufficient notice, that basically a client's silence would allow a lawyer to infer that the client has accepted the proposed increase. So that was kind of the biggest substantive change. Everything else that was in, when we go to inquiry 4 and inquiry 5, they, basically stayed the same. The one thing I added there for inquiry 4, was that was the one where we said, well, the fee agreement, it doesn't just kind of like set out, we're going to change it. We might change it. We'll check it and we'll let you know. But they actually put a limit on how much they might increase the billing rate at this periodic mark. And I just added some language here just to kind of say that, although that's permissible for one, and it may not be required, but lawyer is encouraged to still provide that client with some sort of reasonable notice that, hey, this is coming up. It's just an encouragement, not a requirement, because I think the specific reference to a percentage increase in that fee agreement, the original fee agreement, is the notice that the client needs to have. So that's the opinion where it is now. I think that matches where we were going, but I'm interested to hear all your thoughts. And I want to particularly point out Elizabeth has joined us because I know during the January meeting she had mentioned the difference that sometimes her firm deals with regards to kind of larger clients, corporate clients, or what have you, and how this may not mesh with the practice concerning those types of clients. And Elizabeth also has to leave at 12:30. So I want to hear everybody's thoughts, but wanted to kind of maybe offer an opportunity for Elizabeth to share that concern that she had.
Thank you, and I really appreciate you guys entertaining the comments. In light of my need to go soon. I think so first, I think some of what you proposed here, Brian, would have addressed a couple of my thoughts, just to say what they are, and you can test whether true. One of my questions was, is 20% inherently egregious? The prior version was giving me that sense. I don't remember if I shared this story yet, but we have corporate clients who will require us to hold our rate as is for 2 and 3 years. And then after that time's gone by, it can sure be 20%. My sense is, from what you just explained, given that context, we'd now have the opportunity to decide whether 20% was okay or not in light of circumstances.
That's correct. Yep.
Okay, that's helpful. For interest, another thing that has happened with big corporate clients, it seems to be a trend. They want the attorneys billed by rank, not by years experience. And so we end up with a blended rate. So in our firm, I think like most, you make partner in like year 7, 8, 9, something like that. And then you keep going until you die, if that's your preference. So you can have decades more experience and therefore a different billing rate. We have to find a fair rate and bill all the partners at that same number. And that's what the clients tell us they want us to do. and we give them the number so they're not like unaware of it. But it does mean it's a big percentage increase for those junior partners if you went biller by biller. Does that
Gotcha.
explanation make sense?
Yeah, no, I don't think this opinion would prohibit that. You know,
Yeah,
I think that's kind of again that part of that clearly excessive
yeah,
question, and
that
it's
makes sense
just
to me.
yeah, and it's just kind of a broad sort of analysis for everyone.
Okay. The other question or thought that may have been addressed, it seemed, I think it was in part because you all wrote a very good but seemingly egregious hypothetical, and then you sort of like stood up and knocked down all the ways to fix this really egregious problem. So I might be overreading it, but I got the impression that giving the client notice and an opportunity to object would not be okay. But sometimes that is what happens with these big corporate clients because A, they say it that way in their terms. Um, and then B, we have to put the rates and invoices into a billing system that is theirs line by line. It's not like a single document. And they will just like knock it back if they don't like it, but there's no other communication than that. So
Mm.
it feels to me like a notice and opt out by them. Again, I just saw them, but it seems like your changes might help there too. Do you think so?
Yeah, I think so. That was kind of the big thing that we were discussing last time.
Mhm.
And Lori and John and Davis, feel free to chime in as well. But I felt like our issue was, you know, whether the increase is or is not permissible is going to be the clearly excessive thing, and we're not going to micromanage and try to set a floor. Like anything above 15% is not
Yeah.
okay, you know.
Mhm.
So, but then when we get to notice, as like the client just needs there needs to be some transparency. The client needs to have that notice and the opportunity to actually say, you know, hey, whether it's an objection that
Yeah.
results in some sort of compromise, or whether it's an objection that empowers the client to say, I got to go somewhere else. You know, I got to find
Yeah.
a
Yeah.
different attorney. At least they have the opportunity before it's actually imposed. And now this has this, and that was even to go further in this particular opinion to recognize that if the notice is provided to the client and the client doesn't object, that the
Mhm.
lawyer can proceed. You know, you can infer acceptance of that proposal. So yeah, I think it sounds like these changes may have kind of addressed the
Yeah.
concerns.
I think so. The only
Unknown.
thing that, oh, good, sorry.
So this is Lori, and along those same lines that Elizabeth had raised, like I um I would delete in uh un in the first opinion, it says reasonable notice to client regarding the increase in purple. I would
Uh-huh.
delete to allow input from client. And under opinion three, and actually, I would delete the word proposed because to me, when I send out a notice, it's a notice of the fee increase. And I feel like saying proposed and to say to allow input from client makes it sound like you're opening the door to a negotiation about your fee. And if you're sending out a notice saying, you know what, my fee's going up and it's not excessive or clearly excessive, and it's something that you do annually or you do, as Elizabeth said, at certain moments, say, you know, after the 2 or 3 years required by the corporation,
Mhm.
I really don't, I don't think it should be put in an ethics opinion that it's proposed because um, I don't know, to me, they're going to accept it or they're not. And maybe they contact me and want somebody else to work at a lower rate on their case that's in the firm. But we don't really send ours out as though it's a proposal. It's
Yeah.
a notice given enough in advance.
I'm fine with that. I don't know if anybody else has thoughts on that. My personal just reaction is this whole thing, when you send the notice of an increase, I mean, in some ways it's kind of inherently a proposal because the person's going to say, I don't accept it or I accept it. And
How
that's
about
it.
Yeah.
using the word
Yeah.
intended? I mean, I agree with Lori's conceptually.
Yeah.
It isn't a proposal. It's not really a negotiation. And they can, certainly they can call and talk about it, but I also hear your point. I mean, would the word intended?
I think intended's a good word. I
Okay.
liked intended better than proposed.
Elizabeth, what do you think?
I don't care a lot. I'll say it is definitely the case that I am not going to get paid, whether it was intended or proposed or neither, if they don't like it. So sort of don't care. I would only add that there are times when this is happening simultaneously, and again, I'm trapped in these e-bill systems, but so they have us upload the rates in a spreadsheet and we upload the invoice as a spreadsheet. So it's not like there's advance notice, if you see what I mean, but definitely they're not going to pay the uploaded invoice until they've approved the rates, which they do by absorbing it into the system. So it's all very like on their end, but somewhat implied and can be happening at about the same time. If you all think that is unethical, please tell me. But then I just need to tell
No,
the
but I
big
think for,
corporations.
Maybe you say customary in there somewhere.
and Brian, you need to put an intended increase right there in the middle. You see there's that little underline. I'm pointing at it like you can see where I'm pointing.
Let's see where. Oh, yes.
Right there.
Yeah.
I did
I do
that just
think-
to see if anyone was paying attention.
I
So
was.
Heidi,
I was late, but I was paying
Only
attention.
Heidi.
gold star.
Yeah. Woo! I do think intended is better. And I had circled the same word, Lori, when I looked at what Brian sent us yesterday. So I agree that as if you're putting an opinion out there, for everyone to read that.
Yeah. Can I go back to Lori, your comment about this? You said you would just delete, you didn't think this was necessary language here in opinion number 1?
About reasonable notice to the client regarding the increase. Maybe just say reasonable notice to the client regarding the intended increase. And then I think you can put a period and delete to allow input from the client.
I like it.
And is it right, guys?
If the client has feelings about it, they definitely will reach out.
They'll
I
tell
think
you,
in
yeah.
all of our circumstances. So maybe the answer to Elizabeth's concern is, reasonable notice. It depends on the client, right? Like reasonable notice to my clients, I send a notice at least 30, usually 60 days in advance. But in Elizabeth's case, she's just following what's like the customary practice. So maybe where we talk in here about was notified of the specific proposed increase to the hourly rate at least like 30 days prior. Maybe in that opinion 3, build something in about
kind of in accordance with the customary practice, I think is what you're.
yeah.
Can I throw in there that I was wondering if I was overthinking this the whole time, and I might still be, but I did sense, guys, that this is situational. So a corporate client with tons of in-house counsel and tons of law firms is very, very different than a normal human client who's getting a divorce, even the matter's much more high stakes and such from their perspective. Is there an opportunity for a brief inquiry and an opinion that just acknowledges that, so it's clear to people they can apply context to both who is the client, the nature of the matter, all that good stuff? Or maybe there's already an opinion I'm ignorant of that we can point to for that concept?
Is that an issue that goes only to the type of notice or amount of notice?
I think I'm getting the sense from the edits in the conversation, there's a few factors in here. It's certainly the sophistication of the client. It's the lawyer's leverage versus the client's leverage, right? Like, can you get another a family law counsel in the middle of your domestic matter is a little different than whether my corporate client can find another privacy matter on kind of a vanilla compliance issue, right? And then the amount and nature of the notice, they don't need or want from me a 60-day written, thing. So all those things seem kind of situational, and because you all presented a good use case that is more likely to result in egregious outcomes, I think it made it harder for me to think through my customary practice situation.
Yeah. So what would you all think of doing something here that basically is what is reasonable depends on blah, blah, blah. Like I need to finesse that language. I'm not going to try to draft right now. But if we included that sort of thing, because we're talking about, just kind of in setting out this rule, it can't be clearly excessive, but generally speaking, lawyers can renegotiate, and it must be made with reasonable and freely and fairly by the client having full knowledge and all that. What's reasonable notice or what's reasonable to provide the client is going to be dependent upon, a variety of factors, including kind of the type of practice, I think it's the customary practice for that client, any prior experience with the client. I mean, you could have, it's one of those things, if you have a client that you cannot reach because I don't know, it's a military client, they're overseas somewhere, and you give them a day notice, they might not be checking their email the way that somebody else is checking their email, that sort of thing, just to kind of articulate that the circumstances surrounding the representation, particular attributes of the client should just be factored in determining what is reasonable. And I know that is something that, to the extent that, when I was talking with somebody in the Office of Counsel just earlier who said that they might be watching this. So if they're watching this right now, I know that creates a very squiggly line for enforcement. But I think that's really the best guidance that we can give, because it is going to be dependent upon the client and the circumstances and the practice. So what do you all think of something like that, to include that language at the end of that paragraph? And then we go into, here in this scenario, this was reasonable.
So you basically, what is reasonable depends on the client, the practice, and the customary interactions, or whatever it was. I mean, I actually agree with that. It's hard when you're trying to write an opinion like this one that has to apply to such a myriad of different contexts and clients. I mean, Elizabeth and I laugh all the time, the difference between sort of what she does and I do, and the clients and their expectations. So,
Well, they're both a little nutty sometimes. Other than that, they don't have much in common.
Yeah.
So I think allowing for context to help define what's reasonable, I think is important when we're trying to write an opinion that is global in its application.
Yep.
Yeah.
John,
That
does
makes
that
sense to
answer
me
your
too,
question?
because your hypothetical is a good bad situation you want to knock down, and then you can give the overthinkers like me the opportunity to think a little more about our context. Sorry, go ahead.
Yeah, and I think it is very dependent. I represent a lot of public bodies, and they want to have their notice of increases provided early in the budget process. So
Right.
I had to send my proposed increases out to them
Intended.
2 months ago, and they're not going to be effective until July 1. So
Right.
it is, but ordinarily for somebody that's going to pay their bills, in a different way, 30 days would ordinarily be the same, sufficient. But I agree, it is situational. It does depend.
Yeah, it's a good example, John.
Yeah, that's a perfect example of the complete differences in all of our practices, and how you have to have some flexibility in what's reasonable. I mean, I don't think you can make a rigid definition.
I had only one other thing that I thought it was technical, or maybe just semantic, but I don't know. The more I think about it, the more I think it might be worth talking about. The way you've cast this, Brian, which I agree with everything, but you focused on whether the increase is clearly excessive or not. I guess I was thinking that shouldn't it really be that whether the resulting fee is clearly excessive or not? I mean, I realize that if you have a currently reasonable fee and you propose an increase that's going to make it excessive, then presumably the increase itself is excessive. But it just seemed to me that what all the discussion in the prior opinions has been about the fee, and so I wondered if we wanted to focus on that.
I think you're spot on with that. And I think that's a good distinction because you're right. You could have some 5% increase doesn't seem like a lot, but when you're already billing a clearly excessive fee of $5,000 an hour, then you're still in clearly excessive.
Yeah.
We
Yeah.
can't all be Heidi Bloom, it's just, it is what it is. But no, I don't think that's semantic. I think you're right. And really that was my intended thought, and I appreciate you pointing out that's we're kind of talking about something different. So let me change that
Okay.
to
think it just
focus on
appears
the
in each
fee,
one
the
of the
resulting
proposed
fee.
opinions.
That's a great catch. All right.
No, I think you probably already know this, but back to the provision we were talking about, deleting in 1,
Yes.
you added reasonable notice to client regarding the increase or the intended increase, and then the
Yes.
deletion of to allow input from client.
Yes.
Maybe put the words in this particular example, regardless of the client's purported consent, lawyer's inclusion of inclusion of a provision in the fee agreement that grants
Right.
lawyer the authority to unilaterally increase, because it sounds like Elizabeth may have something allowing for a unilateral increase in her contract. So I think we need to put some limiting language on this sentence.
Yep. I added in this scenario, regardless of client's purported consent. Yeah. Good catch.
And this does not address flat fees at all. I had actually under inquiry 2
Mm-hmm.
highlighted the fact that it was just about the increased hourly rate. I don't know if we want to address flat fees or other types of fees, percentages, or if we're just leaving this to hourly.
I mean, I guess I think this applies to both hourly and flat. If for whatever reason you've charged a flat fee and you come back and you say, you know what, I need more. I charged you, $10,000 for this. Turns out I need 20. If 20 would be clearly excessive just because you're spending more time on it, it's more difficult. And 20 would actually be clearly excessive, then, otherwise you're going to withdraw if they don't pay you more. But I don't know. I mean, that kind of gets into almost like a legal contractual issue, because you've agreed to do a service for that amount. Yeah, I don't know how.
Well, and some firms have fee schedules, have flat fee schedules. But I don't know and we don't at my firm, and so I don't know if they ever if they say we adjust our flat fees annually. I just don't know because I'm not in that kind of practice. But I know that there are some family law practices that do just charge flat fees.
I'd be a little concerned with opening the door with that because it just seems like Brian said, if there's a flat fee contract in place, then there's already an agreement. There's nothing to change. If you start trying to change that,
But what if it were?
I don't see it as an ongoing representation of, like that's going to go on for years for one flat fee, I guess. I don't know if those contracts exist.
So what I mean is if we're going to take a deposition, you need to give me $4,500. if we're going to have a trial, you need to give me $10,000. If you need, so there might be a provision in that contract that says these, the rates, the flat fees quoted herein may increase annually or may increase by 3% a year or something like that.
I
And
see what
so,
you're saying. Yeah, because
right,
it's yeah, you're setting out the expected charges should we reach these
right.
different points. But if it's a year or two later and it's like, you know what? Yeah, it's gone up. Does the lawyer, like, I guess that's where I mean, it's a fascinating thought. I'm kind of playing in my head, is that actually a new contract that the lawyer's making with the client when they say, all right, well, I took you through deposition, now we're going to trial, and my fee actually did go up. It's now $12,000. You know,
Let
can
me
you
give you another
consider that
example.
with some language in the fee agreement that kind of says this is expected, but they might be subject to increase because they haven't technically agreed to take it to trial just yet. You know, I don't know.
Well, here's another idea. We years ago we represented this company that hired us to handle unemployment hearings on behalf of a group of their clients at a flat rate. And I can't remember what the rate was. Let's say it was $400 a hearing. And we entered into this fee agreement with them. And after a couple of years, the cases just went away. But had we continued doing it and wanted to do it, but wanted to increase that fee, to me, that's the same kind of thing we're talking about. We're talking about increasing a flat fee. And I don't see how the principles are really any different. I mean, it would just be the same kind of thing. We'd need to give them reasonable notice under the circumstances of the intended increase and then decide where we go from there. That's an easy situation. The harder one is where you've got one client that you've got this one agreement with and you're doing a variety of things.
Mm-hmm.
And then, as Davis was saying, the scope of the representation changes. Are you bound by the original flat fee agreement? Or is it something where, you know, I mean, I feel like under the comment to Rule 1.5, it seems like it already contemplates that, you know, you can seek to renegotiate the fee agreement in light of changed circumstances. It seems to already address it, but in terms of these mechanics, I think they're equally applicable.
Yeah.
Hey,
I think
Brian,
so too, but that's why I didn't know if you wanted to mention that it would apply in a flat fee situation as well. I just a thought.
So Brian, can I ask a quick question? I'm so sorry. I
Yeah.
apologize for being late. So if you guys already covered this,
Yeah.
I'd be grateful for a summary rehash. On inquiry number 2,
Uh-huh.
I don't love that answer. And I'm being kind. Like, I understand what you're saying, but I'm assuming that this is going to be printed out there for all the world to see, either in the pretty gray book we always get or on the website. And clients are going to see this and know that they, at that point, hold all the cards. And so how are you ever going to get someone to pay the increased fee? And what's the lawyer supposed to do here? So did you guys talk about this, and you can just fill me in?
No, we didn't. It was and I guess that I only explained it that it was under that prior scenario or the initial scenario where lawyer has already completed work at a higher rate and basically told the client, we're at a higher rate, I've already done stuff, and then the client says, whoa, wait a second, I don't agree with this, and lawyer says, all right, then I'm out. And it's that question of coercing some sort of fee. I wonder if it's would it be, see, I guess I see what you're saying, because at that point, if the client says, no, I don't want to pay this fee, even though there's something that's already due, the lawyer isn't going to be shackled to the client forever. Now it's like, now essentially you have notice, and you're trying to, if the client just refuses to pay at that higher rate, then I wouldn't say lawyer is forever stuck with that client. So
Can
yeah,
you
maybe
scroll up
to add
again
some-
real quick? I don't have my hard copy in front of me, and
Which one? What are you looking
I
for?
wanted to see same facts as inquiry one, because what I hear you saying is, well, this response was intended to apply only to those facts.
That's right.
And so,
Maybe add where a client was given no notice of the increased fee. I mean,
Yeah, but even
but
then,
then
I
we
see
might
what
run
Heidi.
into the situation Elizabeth was talking about where they don't give notice.
Yeah.
They don't give notice.
Well, and I see what Heidi's talking about, that even
Yeah.
even if, like, once you get there, can you immediately withdraw?
Yeah.
Maybe not just to coerce something, but after the client has had an opportunity to react, if there's just not an agreement under 116 or Rule 1.16, a lawyer may have grounds to withdraw at that point. So I see what you're saying, Heidi. It's a bit too absolute.
it is. That's a
And
good way to put it. It's
yeah.
very absolute, and I don't see it as that absolute, and I
Mhm.
certainly, I don't know. I think it's pretty stark. Now, do I have the solution right this second? I'm not sure, but
So I think there are probably other factors that need to be taken into consideration.
Mhm.
So whether or not there was notice given, whether or not there was any objection by the client prior to services being rendered, or was it not until after they got their bill? And does the client have something set for hearing or some due date that's pending and doesn't have time to change counsel, right?
Mhm.
But I did fee dispute work for years. And I think that, if they have a fee dispute, that's where it needs to be taken. But I don't think that the lawyer is precluded from withdrawing before that fee is resolved, or should have a duty to continue the representation if there's not a meeting of the minds on what the fee should be.
right.
Right.
I mean, at that point, do you even really have an enforceable contract, right? When nobody's happy?
Right. Right.
Well, let me tease this one out a bit. I hear exactly what you're saying. I think you're right. It is too absolute. And it's trying to distinguish between the person that just didn't provide reasonable notice, just impose something. They can't withdraw right then, but essentially now the person has notice. Now the client has notice. So if there still is no agreement after that, then there's got to be some avenue for lawyer and client to part ways, even if the lawyer is the one that's initiating. But it also needs to account for that, like you were saying, Lori, it's somebody, you're 30 days out from trial, and suddenly you're saying, well, here's my reasonable notice. I'm jacking up my rate. Otherwise, you can go find someone else. Like, that's not fair. So,
But also not fair is some of these cases that go on forever and ever and ever and ever. I mean, I know
yes.
Joke have one that's been going on for 6 years. And if
Ugh.
my client every year said, nope, not going to pay, and your opinion says, nope, Heidi, you can't get out.
Yeah.
I mean, there has to be an end in sight that's reasonable here.
And that's not the intention to say don't get out. It was under those circumstances where, like Lori was saying, where the client has received no notice, and basically the lawyer wants to withdraw right then when the client calls up and says, I refuse to pay.
Agreed. That's not how I read that.
Yeah, I see how you're not reading it that way, and that's why this needs to be better. So
Do better,
I'm
Brian.
gonna tease
Do
this
better.
out. Okay, that's really good. That's really helpful.
Yeah, thanks for pointing that out, Heidi. That troubled me, but I didn't have the words you had to pinpoint what the issue was.
Okay, I'm gonna redraft that one.
Yeah.
That's a really good change.
Okay.
This is a hard opinion, Brian. I think you've done a really nice
You've done
job.
a great job. And I think part of what makes it
Yeah.
so hard is it has to apply to all these varying practice groups. What
Yeah.
Davis does is different from John, that's different from Lori and I, that's different from Elizabeth. And
Yeah.
to make a one size fits all opinion is really hard.
Yeah, no, I appreciate that.
So,
This one's
you know,
interesting.
I want to give you credit for that.
Well, thank you. I'll be
Yeah.
sure to put that in the minutes.
Okay. I'm sure. Just like you did the last time where I agreed with Lori.
I made a special note of
You
Heidi
can also
agreeing
say
with
I
Lori.
agreed with Lori here again.
Oh, that's great.
I just become agreeable in my old age. What the heck? Ah,
Yeah. You know, you just finally found your calling in ethics. That's what it
Oh,
is, Heidi.
that's what it is.
All right. Anybody else have any other additions? I know we're hitting 12:45. I've got some rewrites, and what I plan to do then is kind of make these changes, and I'd like to send it out to the committee and you all, the subcommittee. If you all read it and you have individual feedback, just send it to me directly. But otherwise, if I hit the nail on the head with these changes, then let me know, and we wouldn't need a new meeting. But if you want to have a meeting, just, again, tell me, because we do still have time to schedule something.
Yeah.
So,
Great.
Mr. Subcommittee Chair, is there anything else that you want to address?
No, I hope y'all can tell that I don't have a lot of experience writing billable fee contracts and so forth. So I don't, but I think y'all
You're lucky.
nailed all the issues. And I agree with Brian that with y'all that Brian's done a great job of writing this. So thank y'all for y'all's participation.
All right. Appreciate you.
All right, go get him,
Thank you.
Captain. We look forward to the rewrite.
Yep.
Yep.
Looking forward to it. We'll talk to you guys soon.
All right.
See ya.
Thanks, guys.